Hi there, my name's Miranda Dressler and I'm an attorney with the law offices of Bridget Mackay in Petaluma, California, and we practice in the areas of estate planning, estate administration, and elder law. And today I'm going to talk about planning for your beneficiaries, because many people think that they have to take a one-size-fits-all approach when they're doing their estate plan. Let's say they're doing their trust, and they're planning for the distributions to their beneficiaries, most often their children. But a one-size-fits-all approach really might not be right for most people. It really depends on the specifics of your own situation, and this is really something that you have to think about and plan for in advance, because once you've passed away, the successor trustee of your trust really isn't going to have any discretion to adjust how you've provided for the distributions in your trust if things have changed. They have to follow what you have provided for in your trust. Okay, so the first thing that the first one-size-fits-all approach that many people feel they need to take is that they need to provide for equal distributions to all of their children. But that really certainly isn't a requirement, and it might make more sense, depending on your situation, to provide for unequal distributions. So maybe you have one child who's doing really well and has plenty of money, and they don't need it as much as some of your other children. So it's perfectly acceptable to provide unequal distributions and percentages of your total estate in your trust, depending on what the circumstances are. Another common misconception that people have about planning for beneficiaries is that the only option is to make the distributions to your beneficiaries outright, and so that the beneficiary would just at the time receive a lump sum distribution. But again, that might not be the right way to do it, depending on what your beneficiary's circumstances are. Maybe you have children who aren't financially responsible and couldn't handle receiving just a lump sum distribution of cash or other assets. Or maybe the child has creditors or is in the middle of a bankruptcy. Similarly, maybe you have children who are married and you're not so fond about their spouse and you're worried that they could divorce someday and the spouse could walk away with part of that inheritance. So the other options, aside from providing for just an outright distribution to your beneficiaries, is to instead leave the assets and the inheritance for your kids in trust for their benefit, and what we call subtrusts. And those subtrusts can be designed specifically for whatever the needs of that beneficiary are. So for example, we can provide for the beneficiary who has a creditor problem, we can provide some creditor protection in that beneficiary's subtrust. We can also provide divorce protection for that beneficiary. And that way, each child receives their inheritance, but it's protected for them. And because the ultimate goal is to make sure that that inheritance is received by them, but it's also protected for them and for their benefit once they do receive it. Because you've worked hard to accumulate whatever wealth you have, and you want to be able to pass that on to your children and have it be protected when it gets there. So if you have any other questions about this topic or any other estate planning topic, you should contact an experienced estate planning attorney in your area. Thank you.